Deportation stopped by High Court. Hundreds of deportation are in suspicion after the High Court commanded the Home Office to end exercising a provocative no-warning policy.
Have you visited our website? We have hundreds of updates regarding UK visa and immigrations. Also, if you haven't subscribed the channel, please subscribe now, and press the bell icon, to get the latest updates on your screens.
A charity protecting detainees has succeeded a ruling after declaring the strategy shattered the right to access justice. Medical Justice stated the rule stopped migrants having a reasonable attempt to set their circumstance before they were pushed on a plane out of the United Kingdom. It mentioned the rule had disturbed a vast range of individuals residing in the United Kingdom. These consist of the individuals from the Windrush generation and Praise of Torment, it said. Mr. Justice Walker, after commanding the order, stated the Home Office to discontinue the deportations until a complete review of their fairness. The verdict signifies that the Home Office have to instantly stop 69 deportations, planned for the future days, but throughout the trial, the court heeded that hundreds, if not thousands, of immigrants were undoubtedly in the direction of the rule in any single year. The charity's encounter connects to a scheme called Removal Notice Window, in which an immigrant is provided 3 days warning that they will be deported on any day after that. The immigrant, in that case, be held with no additional notice to all plans, holding classified the date of their deportation and putting a stop to lots of them growing a real dispute. Which individuals been have emotionally impact. On one instance, a suicidal person with an acute psychological disorder was imprisoned and deported on the very same day, only for a magistrate to instruct the Home Office to get him back since he had been negated the option to put his case. In a different scenario, a Jamaican immigrant who had been residing lawfully in the United Kingdom for years was imprisoned with no reason. He struggled for weeks to collect the satisfactory proof of his right to live in the United Kingdom, and he barely dodged being put on a deporting flight. Legal representatives for the charity stated that the massive majority of those aimed had no time to arrange proof or pleas, which they were allowed to hand out to the officials and the magistrates before an urgency to deport them. Charlotte Kilroy QC, for the charity, mentioned the rule was a blatant intrusion with the right to pursue rightness and amounted to a risk to the degree of regulation. She further stated that the rule is hardwired to create a condition where there's no approach to fairness in relation to the verdict the Secretary of State puts together. There is a major possibility that if temporary support is not permitted, immigrants will be deported with no recommendation to the courts. The situation now. The Home Office's usual deportation command continues to be legal, implying officers can even try to deport alleged unlawful immigrants, as long as they are providing an exact date of when it would occur. Legal representatives for the Home Secretary mentioned to the Court of Law that the removal notice window rule had been announced to stop migrants using last-minute efforts to interfere the deportation under the usual practice. But verdict against to the rule, and stopping its practice, Mr. Justice Walker stated anxieties elevated by the charity indicated there had to be a complete assessment in the summer of whether the rule was legal. Greeting the verdict, the charity said, refusing tremendously defenseless migrants access to magistrate on this mammoth extent is a suppressed concern causing acute damage and jeopardizing life.